And we're back on Consumer Choice Radio. I'm very pleased to reintroduce our next guest, who is a Wisconsin-based, now internationally known criminal defense lawyer. He was Steven Avery's lawyer, whose case was featured in the acclaimed Netflix documentary Making a Murderer. And he also happens to be the co-founder, or one of the co-founders, for the Center for Integrity in Forensics Sciences. Thank you very much, Jerry Buting, for joining us on Consumer Choice Radio.
My pleasure.
Awesome. So, thank you again for joining us. You're now a friend of the show, as we like to say, for all of our repeat guests. We couldn't have you on and not first chat about if there have been any progressions in the case for Steven Avery and Brennan Dassey. Although they're two very separate cases, obviously they get discussed very much in that same conversation. Is there anything our listeners should know in terms of where those cases are going?
Well, I don't know how up to date people are on the developments in Steven's case, but it's pending now in the Court of Appeals. The briefing is all done. They're waiting on a decision from the Court of Appeals. The decision could be a number of different things. They could send it back to the trial court for an evidentiary hearing where witnesses can be presented. The state can cross-examine them, and ultimately the trial judge decides if there's enough to grant a new trial or some other additional remedies, perhaps. Since the case was fully briefed, which was really back in January, I think, there's been some new developments, and another witness has come forward and said that he was a newspaper delivery person and actually was there at the Avery Salvage Yard on the early morning hours of November 5th, which is later that morning, the day that the RAV4 was discovered, quote unquote, by these volunteers who were really, I think, working as agents for law enforcement. But at any rate, this witness says that he saw Bobby Dassey and another individual actually pushing the RAV4 onto down the lane that led directly to where it was later found. And he says that he contacted the police after it became public that this vehicle was discovered, and he was basically blown off, said, yeah, fine, we know, we got the right guy. And then didn't really hear back from them, assumed that maybe, this had nothing directly to do with Steven Avery's guilt, and so didn't say anything else until years later when he watches Making a Murderer, and then comes out, says that he tried to contact attorneys, not us, but prior attorneys, other attorneys on the case, and didn't hear back from them, and ultimately made contact with Kathleen Zellner, who now has filed an affidavit with the Court of Appeals asking that the case be set back for that reason, that there be a hearing with that witness. Again, at an evidentiary hearing, the state has the opportunity to cross-examine, to challenge a defense witness, whether it's an expert or a lay witness, fact witness like this person. And so we're waiting to see if at that point the state's opposing it. They're saying that this should not be raised now. The case had other issues had already been briefed, but we have not heard back from the Court of Appeals since Kathleen Zellner filed that additional motion. Brendan's case, by the way, though, is sort of dormant, but not. It's not like nobody's doing anything on it. The last actual substantive thing that happened was when they applied for clemency from Governor Evers, Wisconsin's governor, and he denied the petition. His commission denied the petition very, very sort of cursorily, without any real explanation, other than that the way the guidelines or the requirements for a clemency petition exist right now, you have to be out of prison and off supervision for 5 years before you can apply for a pardon or clemency petition, which of course does nothing for people who are sitting in prison wrongly convicted or with excessive sentences that really should be out. And but there was sort of an escape clause in that if the governor chooses, they could, in certain cases, depart from those qualifications. And it didn't happen here. There are still people pushing for that. And I'm sure that the lawyers behind the scenes are also still working on legal grounds that he might have to raise to try and get his case back in court.
I mean, two very important updates. I know it was tough to see. This was back a while ago when the Supreme Court, I think, did not choose to rule or to adjudicate the Dassey case. But it does bring up another important question, which I'd love to hear your insights on, is why the various reasons why people plead guilty to crimes that they did not do. Obviously, I mean, in my opinion, the Brennan Dassey case is a good example of that. But we've also seen very high profile cases like the exonerated five, in terms of confessions to crimes that they did not commit. And so I'm just wondering if you could educate our listeners as to what the background is on why that happens so frequently.
Sure. Well, there's really two different kinds of things going on. The Dassey case is an example of why people falsely confess to things that they didn't do. And that's one problem that we have. And part of that is because of the techniques that are used, the Reed technique and some of these particularly confrontational interrogation techniques that are still in large practice all over America, that combined with a vulnerable person, that is somebody who's very young or suggestive, or vulnerable adults, can easily be manipulated into saying things that aren't true. And we know that because DNA exonerations, you mentioned the Central Park Five, I think, but in other cases of exoneration where there's actually DNA evidence that proves that the person who was convicted was innocent, when it's juveniles that were involved, about 43% of the time they falsely confessed. And so why? And we know this happens because of, now study after study has shown that certain techniques are more likely to produce false confessions than others. But then there's the other question, which is not just why people falsely confess, but why do innocent people plead guilty? And that's a problem, not just in America, it's a problem all over the world. The UK is dealing with that issue right now, where they've seen a real increase because by statute, they're allowed to get basically a 1/3 reduction of their sentence if they plead guilty early. And so some people are jumping at that even when they're innocent, rather than risk going to trial. And so we have in America something called a trial penalty. It can be applicable in a number of ways. It can be simply because judges punish people more severely if they go to trial rather than plead guilty. No judge will admit that they do that, but in practice, lawyers see it all the time. You should not be penalized for exercising your constitutional right to a trial, your constitutional right to make the state prove you guilty beyond reasonable doubt. But it happens, and we know it happens. It also happens because people plead guilty because they're in custody on bail. This is particularly a pernicious problem when it comes to lower level offenses, misdemeanors or lower level felonies, where poor people are in jail before trial while they're supposedly presumed innocent. They have cash bail on them that is beyond their means, and they simply cannot get out. And they sit for months. And now it's even worse with the COVID crisis because the courts shut down and there are people with speedy trial demands that take precedence over people who have lesser offenses. And so sometimes somebody will sit in prison for 6, 8, 9 months waiting trial because they're saying they're innocent. And the prosecutor comes to them with an offer. Look, if you plead guilty, you'll get off with time served. Basically, you have the key to your jail door. You can walk out today if you plead guilty. And so people do. And they oftentimes do get what they're offered, which is to get out right away. But there's all of these direct and collateral consequences that they face for the rest of their life, whether it's, just having a criminal conviction can have all kinds of consequences in closing doors.
So you're
And so
listening to
that's one thing. The last thing I would say about that real quick is that mandatory minimum sentences that legislatures have passed and put in the hands of prosecutors is another driving factor. So people who, I've got a case right now, a guy who's never been convicted, charged with anything before in his life. He is accused of a one-time incident that is highly unlikely to have occurred. A sexual assault of anybody under the age of 12. In Wisconsin, the prosecutor has a choice. They can either charge as a normal sexual assault would be, for which there's no mandatory minimum. You could get probation in theory, or they can charge mandatory minimum 25 years in prison without parole. And increasingly, prosecutors are using that as a leverage to get people to plead guilty to something less. If you want to go to trial, fine, but the ante is up. You're going to prison for 25 years, never getting out that entire time. Or you can take this deal right now. We'll give you a couple of years or 3-4 years or whatever. And so people who are innocent sometimes are facing these difficult decisions where the risk of losing at trial is too great, and therefore they take a guilty plea.
You're listening to Consumer Choice Radio. We're speaking with criminal defense attorney Jerry Buting. He's also the author of the book Illusion of Justice, which we'll link to. Jerry, the last time we spoke, it was April 2020. We were in the midst of the pandemic, the very beginning, and basically a month later, all of the eyes of the nation were on our police, on our court systems, and we've had since that time various reforms proposed, everything from bail reform, like you just discussed, qualified immunity. What is your reaction to this sort of new movement for some kind of reforms, whether it be in the criminal justice system or police, that came in the wake of the George Floyd incident and killing?
Well, it takes a tragedy like that to really wake people up. But I was very encouraged at the initial outpouring of demands for police reform, because there, as I talk about in my book, police reform is only one aspect of our criminal justice system that is in dire need of reform, but it's a big one. It's where people interface with the community. The community interfaces with criminal justice more directly than anywhere else. I can tell you, I never expected in my life to see people walking down the streets with signs saying abolish qualified immunity. It is a serious thing that needs to be abolished, but only lawyers have known this, people in the know. It's amazing that enough people now understand what it is and how damaging it is to fairness in our justice system. Qualified immunity has to go. And what people don't realize about qualified immunity, what qualified immunity is basically is that if it makes it very difficult for any plaintiff, not just victims of police abuse, but any person suing the government, any government individual, that individual is given a immunity, qualified, they say, but as a practical matter, it's become absolute, because the courts have interpreted it in a way that unless there is a clearly established prior case that says what the government person did, police or otherwise, was wrong and improper, then they're immune. And it's a doctrine. It was never passed as a statute anywhere in America, not by Congress, not by any states. It was imposed by the United States Supreme Court in the 1960s. And it later was morphed into such a ridiculous format that it basically, like I said, it does almost give police or anybody else absolute immunity from lawsuits. Here's one example. Some of the people who, when President Trump and Attorney General Barr ordered the area right outside the White House to be cleared of demonstrators and fired tear gas and other things, some of them sued as a violation of their constitutional rights. And the defendants are saying, unless you can show us a case in which a president was involved directly in clearing an area of protesters and, tear gas and on and on and on. The specificity of facts is ludicrous. You would never find an exact situation like that. Now, one thing that's been encouraging is the United States Supreme Court has in the last year started to put a couple of limits on this. They have said that there was a terrible case in Texas where a guy was put in a jail cell for like 6 days or something. His first jail cell was covered in human feces, practically floor to ceiling. And then they move him to another one in which he basically has to sleep in sewage in a cold cell. He sues. And the lower courts say, well, there's no case where it's clearly established that we can't put people in, make them sleep in sewage. The US Supreme Court reversed and sent it back and said, look, that's obvious. No correctional person could think that that was constitutionally acceptable, even though there wasn't a clearly established case where that had been said. So there's some cracks coming from the Supreme Court, from the most conservative areas of it. Clarence Thomas is one of them. But really, it needs to be, the people need to take it back. It needs to be abolished by Congress and state legislatures. Colorado, I think, has already abolished it for state lawsuits. But when you sue the government, particularly if you're suing the federal government, they can always remove it into federal court where your local state statutes don't matter.
Yeah, I mean, that's one where, for those who are familiar with the outlet Reason, they've done some particularly good coverage of the most egregious examples of where police enter the wrong house on a no-knock raid and murder someone, and their family is not allowed to sue because of qualified immunity and all sorts of other repercussions, or all sorts of other really kind of horrific examples without repercussion. Beyond that, another important topic, which as a Canadian is kind of foreign to me, but I know it's quite important and quite relevant in the United States, is the ongoing push to peel back the death penalty. And so I'm just curious as to what your thoughts are on the death penalty, if you have any insight as to the amount of people whom are wrongly convicted who actually receive the death penalty, and things like that. And if you have any positive or maybe negative thoughts on how that fight to abolish the death penalty is going.
Well, yeah, there was actually a recent study a couple of months ago that looked at all of the executions and then looked at and compared that to the number of people who have been exonerated who were on death row. And it's astonishing. Approximately, for every 8 people who were executed, one of them was exonerated. I mean, it's astonishing. And, those 8, 1 out of 8 are, just the tip of the iceberg, I'm sure. We know, even though states have resisted it over and over, we know that there have been innocent people who have been executed. The state does not want people to know that because it will. They fear it will completely undermine the death penalty for almost everybody. And there's an example. I believe it's in Tennessee that a gentleman's daughter, a guy who was executed maybe 10 years ago. There's now DNA that could prove or disprove his guilt, and she believes it will show that he's innocent. And she has filed to try and get a test to prove that, and the state has fought it all the way up to Tennessee Supreme Court, and they ultimately said, nope, you're not allowed to do that. What it is that we know what it is they're really afraid of. They're afraid that there will be conclusive proof that an innocent person has been executed. Even without that, though, I think states are finding more and more that juries are not imposing the death penalty. They're not convicting on the death penalty. When there are other options. And so some of the prosecutors are charging them less and less. And it's really, I think, in large part because people have understood from the DNA exonerations that innocent people can be convicted under the death penalty and executed under the death penalty, and it is irrevocable. You know, unlike all other penalties, you could give them life without parole, for instance, and if later there's proof of innocence, you know, you could save them. But if you execute them, you can't. And so there has been a very big trend. I think now since the death penalty was reinstated in 1976 in America, I think there's somewhere in the neighborhood of 23 or 24 states that have abolished it now. And just in the last 10 years, maybe 7 or 8, including a couple of months ago, Virginia, which is the first Southern state to abolish the death penalty. It's not just the unfairness of executing an innocent person, but also study after study has shown that it is just disproportionately applied to people of color, poor people. You know, that's always been the case, but it's becoming more problematic for the citizens now, and the voters, and the support for the death penalty has gone down and down and down. It's also extremely expensive because it is irrevocable. We have all of these appeal rights that somebody who's convicted of a death penalty has that maybe the ordinary person doesn't have. And so there's appeal after appeal after appeal, and there's all of these pretrial measures that need to be applied. It costs millions of dollars for each death penalty prosecution in this country. And some people are thinking it's just not worth it. You know, there are other alternatives that can still protect the community without taking that fundamental ultimate decision that the government really should not be doing in the first place.
Yeah, and if we even look at South Carolina, if we're going to go ahead and ring on the South, we also saw that they, because of the price of the drugs that they use for the lethal injections have gotten so high, or there's not enough supply, they've put firing squads on the table. Next level of craziness, we're speaking with America's defense attorney, Jerry Buting. You can follow him on Twitter at jbuting. I have a question, Jerry, about what's happening with cannabis legalization and some of the legal efforts around expungement in states where it is legal. So this might go back to your law school days. Are there examples in the past that we can learn from about how to do this correctly? Are there states that have done this in a good way? I know it's already being discussed in New York and some other states. But what is the way forward once cannabis is legalized in various states to actually expunge some of the records of the people who've been convicted under this, knowing that it is on their record when they go for a job or to try to rent an apartment? Is there any kind of history about how we can do this correctly?
There is, and it's not just people who have criminal convictions with consequences that gives to their life. There are people in prison on simple possession of marijuana still. And in fact, just last week, I think it was, the Supreme Court upheld a Mississippi case where a guy was convicted of possession of 43 grams of marijuana. And because he had a prior 2 offenses, which were relatively minor, but one of which involved a burglary, which had later been defined as a matter of course in Mississippi as being a violent offense, even if there wasn't any actual violence in it. He got mandatory life in prison without parole for 43 grams of marijuana. And yeah, most people are shocked. It's like, are you kidding me? It's legal in our state. But most states, it's still not legal in America. And those places where it is, there has been a move to try and expunge those records, remove the convictions from people's records, because it does have lasting effects, even for people who don't get the draconian penalty of a life imprisonment. It makes it harder for them to get jobs. It prevents them from getting certain licenses. And, you're a convicted criminal with that kind of record. Now, there's always been the opportunity for a pardon in most states, except in Wisconsin for 8 years when Governor Walker was our governor and departed from hundreds of years of, or over 100 years of history where governors exercised that pardon. He refused to pardon anybody for 8 entire years. But it's back now. Our governor is using it. It is available and has been available for people all along. if, let's say, 25 years down the road, you apply, you had one marijuana conviction and you want to get it removed from your record. But that takes forever, and it's just taking tiny bites from the apple. There are states that are really trying to change that with second chance type bills that will retroactively expunge a prior criminal conviction based upon possession of marijuana. It can be done. There is, I think, a pretty strong movement in those states, particularly where cannabis possession is now legal, to do that. And that's encouraging because there are many people who really do have that as their only conviction and really could have a lot more doors open to them, opportunities open to them, if they could have a clean record.
Yeah, and like you said, there are people who just have possession records, and then there are another subset of people whom have had possession kind of leveraged against them in whatever else they were in trouble for lack of a better word, which really raises some questions of like, you were you were stop and frisked and they found cannabis on you, which then led to further charges. There are all sorts of questions of that kind of domino effect. And so, I mean, I know that in the Canadian instance, yes, we have federally legalized cannabis, but there are still some serious lingering issues with actually ensuring that everyone has their record expunged or gets a pardon. And it's one of those things where it's like people forget that the reason we've legalized in the Canadian instance, and then for specific US states, is that cannabis never should have been illegal to begin with. In the same way that alcohol prohibition was a complete failure, and we all kind of in hindsight realize that. And so, yeah, it'll be interesting to see how that progresses in these US states, or if the Biden administration will maybe make some gesture in that direction, although it's unclear as to how far they would be able to go if the federal government does descheduleize cannabis. And so with that, in terms of the Biden administration, just in closing here, I'm curious as to what your feeling is in regards to criminal justice reform under a Biden presidency.
Well, he campaigned on a real effort to reform the criminal justice system. And a lot of people may not understand this, but President Biden is the first American president opposed to the death penalty across the board. He is a devoutly Catholic man, goes to mass every single week. The Catholic social justice principles have been opposed to the death penalty for any reason for a long time now. And Pope Francis, in fact, recently declared it inadmissible, is the actual term that they use for any circumstance. So it's interesting that we now have a sitting president in office who is opposed to the death penalty. And that's just one aspect of criminal justice reform, of course. We talked about that earlier, but he is also, there's been a number of things, like, for instance, recently that it was discovered that under the Barr administration of the Attorney General's office, the Justice Department was secretly getting emails from reporters from the New York Times, Washington Post, other organizations, in order to try and investigate leaks. And that actually continued into the beginning of the Biden administration, that kind of surveillance, secret surveillance of reporters. And it was, when it became public, I believe they just announced recently that they're now no longer going to do that. And, that's improved, the reason for encouragement as well, that I think in a lot of different ways, the Biden administration will, and I think Vice President Harris will also join in reforming criminal justice. But of course, that's at the federal level. Other than being a bully pulpit to try and get the legislatures, the state legislatures, to do something, in America, we have 51 criminal justice systems, the federal government and 50 other states, plus the territories. And each one of them they're all bound by the federal Constitution, but there's a lot of areas where that has been held not to apply, or that it's broad enough that it allows an awful lot of abusive practices still at the state level. So, Congress could pass laws that would then statutorily be binding on all of the states, and that's the easiest way to really get reform. That's why there's this police reform bill pending right now that would abolish, for instance, qualified immunity. With one signature, the Congress and the president could abolish qualified immunity in all of the states. It would be, they would be required to do that. Otherwise, it's going to have to be piecemeal, for everything from reducing mass incarceration to improving funding for prosecution and defense in criminal justice systems, to a lot of the different procedures that apply even before you're charged or after you're convicted. Those kinds of things, I think the Biden administration is going to be looking at. We are still a very divided government, unfortunately. And even though criminal justice reform in recent years anyway has been a nonpartisan issue, people on both sides of the aisle have recognized the need for reform. Too often it has gotten bottled up in bills that have other kinds of very, very partisan disagreements and get stuck and nothing really happens. So we'll have to see. Ultimately, the people through their representatives at the state and federal level need to be heard and demand change, because it really has to come. It's going to come from the bottom up. Any reform is not ever going to start at the top unless there's a real groundswell of movement from people who most suffer from the abuses we have right now.
And I think there's been plenty of evidence that we have that groundswell now. So we've been speaking with criminal defense attorney Jerry Buting. You can follow his work on his website, jbuting.com. Jerry, thanks so much for coming on Consumer Choice Radio.
Thank you. It was my pleasure.